Court fixes October 27 for judgment in Nnamdi Kanu suit against FG. Good morning, good afternoon, good evening. Welcome to Emizare News. Now we dey bring you the topmost news and everything wey dey happen for all over the world. We are listening to the news proper. The Federal High Court sitting in Umuahia, Abia State has fixed October 27 for judgment in the suit filed by the leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, against the federal government. Kanu, in the suit filed on his behalf by his special counsel, Mr. Aloy Ejimako, is challenging his extraordinary rendition from Kenya by the agents of the federal government. When the matter came up for hearing on Tuesday before the court, counsels to all the parties adopted their writing application and processes. However, counsels to the federal government, Simon Enoch of the Federal Ministry of Justice, in adopting his written addresses, prayed the court to dismiss the suit, claiming that it is an abuse of court processes. He argued that the matter had already been decided by the Abia State High Court and further claimed that Kanu had earlier jumped bail before his arrest in Kenya. But in a swift objection, Kanu's lawyer reminded the court that the case decided by Abia State High Court was different from the current suit, as the former only dwelt on the military invasion of Kanu's house in 2017, which was decided in his favor. Kanu's lawyer argued that the substituting suit was on the unlawful rendition of Kanu from Kenya to Nigeria by the agents of the federal government without any warrant. He insisted that the federal government should be made to produce the legal instrument or authority upon which the abduction or extraordinary rendition of Kanu was based on. My client remains an unlawful expelled individual and cannot be subjected to any trial because he was unlawfully renditioned, Kanu's lawyer argued. He further reminded the court that the United Nations Commission on Human Rights had already directed the authorities to unconditionally release Kanu and compensate him for the violation of fundamental human rights. Ejimako also informed the court that Kanu's health condition was deteriorating and he urgently needed the attention of his personal physician. According to him, Kanu has to be alive first to take his trial. After listening to the argument and submission of both counsels, the presiding judge, Justice Evelyn Ayadike, fixed October 27 to deliver judgment on the matter. Later, in an interview with newsmen, Kanu's lawyer said that the IPOB leader would first be released from detention and be returned to Kenya or Britain, where he was residing, before the federal government would apply for his extradition. He argued that in law, you cannot detain somebody you don't have the authority to arrest. Kanu's lawyer likened the rendition of his client to the attempt kidnap of former Minister of Agriculture Alhaji Umar Diko by the federal government from Britain in 1984, in which those involved in the act were arrested and prosecuted and Nigeria punished by the United Kingdom. He further said that Kanu's quest for a referendum on Biafra was not a crime, as part of eastern Nigeria was lost to Cameroon and part of southern Cameroon became Nigeria respectively via plebiscite. Ejimako, however, expressed hope that his clients would get justice in court, saying that his case is very clear. Some of Kanu's legal team members at the court hearing were Patrick Ajezie, Ifeyinwa Nwogu, Tochukwu Arubonye, Franklin Amande, Oheto Wazie, and Mandela Umeborogo. Kanu's younger brother, other family members, Jewish rabbis, and numerous supporters were also cited at the court. Below are some of the reliefs being sought by Kanu. First, a declaration that the arrest of the applicant in Kenya by the respondent agent without due process of law is arbitrary, and the respondent enforced disappearance of the applicant for 8 days and their refusal to produce the applicant before a Kenyan court for the purpose of applicant's extradition is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right against arbitrary arrest, to his personal liberty, and to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. Second, a declaration that the detention of the applicant is a non-official secret facility in Kenya and the torture of the applicant in Kenya by the respondent agent is illegal, unlawful, and unconstitutional, and amount to infringement of the applicant's fundamental right against unlawful detention, torture, and to fair hearing as enshrined and guaranteed under the pertinent provision of the CFRN and Charter. Thirdly, a declaration that pursuant to Article 12(4) of the Charter, the expulsion or extraordinary rendition of the applicant from Kenya to Nigeria by the respondent without a decision taken in accordance with the law of Kenya is illegal, unlawful, unconstitutional, and amounts to infringement on applicant's fundamental right to fair hearing and not to be expelled from a state party to the Charter except by virtue of a decision taken in accordance with the law, as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. Fourth, a declaration that any criminal prosecution of the applicants, the purpose of which the respondent unlawfully expelled the applicant from Kenya to Nigeria is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental right to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. Fifth, an order of injunction restraining and prohibiting the respondent from taking any further step in any criminal prosecution of the applicant enabled by the said unlawful expulsion of the applicant from Kenya to Nigeria. An order mandating and compelling the respondent to forthwith restitute or otherwise restore the applicant to his liberty, same being his state of being as of 19th June 2021, and to thereupon repatriate the applicant to his country of lawful domicile, to wit, the United Kingdom, to await the outcome of any formal request the respondent may file before the competent authorities in Britain for the lawful extradition of the applicant to Nigeria. Number 7, an order mandating and compelling the respondent to issue an official letter of apology to the applicant for the infringement of his fundamental rights and publication of said letter of apology in 3 national details. 8, an order mandating and compelling the respondent to pay the sum of 25 billion to the applicant, being monetary damages claimed by the applicant against the respondent jointly and severally for the physical, mental, emotional, physical, property, and other damages suffered by the applicant as a result of infringement of applicant's fundamental rights by the respondent. My people, na so we don see am today for a misery news. As it stands, a new date for Mazi Nnamdi Kanu has been fixed, and that is supposed to be on the 27th of October 2022. So I want you to be all ears and pay attention, as whatever that happens that day will be bringing it to you. Of course, you've heard the suit by Nnamdi Kanu's lawyer, Aloy Ejimako, and he has addressed the Biafran and also addressed the newsmen for them to be able to understand what is actually happening. Let me draw the curtain here. Don't forget that you are still on a misery news. Now we be the correct news. Now we bring you the topmost of the top. wey dey happen for all over obodo. Don't forget to like this channel, don't forget to comment, don't forget to subscribe, don't forget to share, don't forget to on your notification button so that whenever our news enter, na you go be the first wey go see am. Ka Chineke gozie unu. Ka emesịa.